appear for the first and second applicants. The application for leave to appeal are here with Mrs. Flatt, now SC, but it's still coming in from third from her yesterday.
Lords and ladies, I appear for a third applicant with my learned friend Don.
May I please the court, I appear for the respondent in the application for leave to appeal together with Mr. Borgstrom and Mr. Vakele.
Started off by setting out the now statutory requirements for leave to appeal, that the appeal would have a reasonable prospect of success, or that there is some other compelling reason. We submit that on both grounds leave to appeal should be granted. Whilst the test has been tightened up with the word would have a reasonable prospect of success rather than may, and there's now requires more certainty, we believe that there is a reasonable prospect of success and there are compelling reasons which we will refer to. The Erasmus in the commentary on the Superior Courts Act at 82-56 on Section 17, the author states that it is submitted that the substantial importance of the case to the appellant, or to both the appellant and the respondent, constitutes a compelling reason why an appeal should be heard. Other compelling reasons include the fact that the decision sought to be appealed against involves an important question of law, which we will submit, and that the administration of justice, either generally or in particular case concerned, requires the appeal to be heard. We have articulated 6 grounds upon which we rely. The first ground relates to paragraph 64, 65, and 71 of the judgment. In paragraph 71, the court said that the legal authorities, of which Mr. Msheshe has been aware of so advised, do not support the decision taken by him in an instance such as this one under review, where the use of process doctrine is applied in an extrajudicial exercise of public power, but the prosecution use is discontinued. In this instance, the basis of the alleged use of process rested on legally untested allegations, which were unrelated to the trial process and the charges. And then the court said, it is thus our view that Mr. Msheshe, by not referring the complaint of abuse of process and the related allegations against Mr. McCarthy to court, rendered his decision irrational. We submit that is the first ground we rely upon, and we submit with respect that the court erred in finding that the matter should have been referred to court. We start with reference to the Constitution and the NPA Act, which vests in the National Director the power to prosecute, continue prosecution, and to discontinue. And it traverses the boundaries of separation of powers to provide that the NDPP in these circumstances should have to first apply to court before making the decision. And the court relied upon the Hong Kong decision, which went on appeal, which says that the issue, while the issue is debatable and it expresses the better view of going to court, but in those two cases, they are not analogous to the present situation. In both those two cases, it was the accused who applied for a stay. And in those cases, the court said that you must wait the trial. And the trial court will then determine whether the abuse of power was so egregious that it would merit the prosecution being discontinued. That is a far cry, we submit, from a situation where the prosecutor, who is vested with the power to discontinue a prosecution, has to first apply to court. And our submission is that it would lead to an abuse of the process of such an egregious nature that whatever the merits may be, the prosecution should be stopped if in the discretion of the prosecutor he so decides. Of course, a third party, as in this case, can review the decision. And it has been reported, the media being present throughout and again today, it's been reported that this appeal was based on the ground that the decision of a prosecutor is not reviewable. And that is just not so at all. It's never been our ground, and everybody accepts, and it's trite, that the decision of a prosecutor can be reviewed in terms of the principle of legality, in terms of the Constitution. It's not a budget review, but it can be reviewed. So we accept that. But that is a far cry from saying the prosecutor who wants to stop the prosecution must first go to court. And it would lead to an absurdity where if the prosecutor thinks that there has been such a serious abuse that should not carry on, that he in the meantime, or she must in the meantime, carry on with that prosecution for maybe a year or 2 or 3 years to find ultimately that when they get to court, the prosecutor stands up and says, we believe there's been an abuse of process, and the accused no doubt will latch onto that and say, I agree, and the court's got no power to intervene in order for the prosecution to carry on. But in the meantime, it would be an act of bad faith on behalf of the prosecution to proceed down the road of a prosecution knowing full well that there has been an abuse of power. So what the prosecutor is entitled to do in terms of the act is to stop the prosecution if he thinks that that is what it merits, and a third party can review that. But the court can't intervene in that process. So we say that analogizing the facts of H. Sor and Latif to the present matter was not apposite, and this is a matter which now impinges seriously upon the prosecutorial process. If in other matters the principle is that before a prosecutor can discontinue a prosecution because there's been an abuse of process, that prosecutor must first apply to court. It provides a principle which affects all prosecutions where a prosecutor decides not to continue.
And are you saying that the court held the prosecutor must first apply to court before you can take a decision?
Well, that, my Lord, is what is stated in paragraph 71 of the judgment. It is thus our view that Mr. Che, by not referring the complaint for abuse of process and the related allegations against Mr. Parton to court, rendered his decision irrational.
But you must look at the whole circumstances of the case, and the background of the case, that the decision had already been taken to the matter of court.
But my Lord, a decision had been taken, and it was within his power to change his mind, which he did, discontinue the prosecution, and leave it at that. He didn't have to now go back to court and ask the court for permission to stop the prosecution. I mean, my Lord, it may happen frequently that during the course of a prosecution, certain facts come to the attention of the prosecutor, which results in him informing the view that the prosecution should not continue. He may be sitting with a statement from somebody. He's proceeding on the basis of that statement, then receives information to say that that statement was a lie, it's not true. The same as come to court and ask the court if he can discontinue it. my Lord, it breaches the separation of powers. That is the very power that is given to the prosecutor in this matter.
I understand your submission to be saying that we are saying in our judgment that Mr. Mumsek should have first gone to court before taking a decision. That's not what we are saying.
Lord, I'm reading from the judgment. It says that Mr. Msheba, not preferring the complaint abuse of process, took by court rendered the decision irrational.
Well, that's the conclusion of the paragraph that we use. Before the paragraph, the judgment sets out exactly that Mr. Msheba himself took the decision to challenge the veracity of the allegations against the party. And he felt that these need to be proved first on the basis of objectivity before he made the decision. Then without explanation, it's just changed and abandoned. Now what we are left with, and these are the questions that we raised earlier, what we are left with is a decision based on allegations that are untested in the court of law. Spy tapes that were there, there is no evidence that these were authorized by a judge. Secondly, you have allegations from those countries which have not been verified as being authentic. And thirdly, that Mr. McCarthy himself has not been given an opportunity to explain his questions. Now, all that within the context of international, that's what we proceed. It was not in the judgment saying that we are establishing a principle or a precedent that whenever the prosecutor has to take a decision, must go to court. This is how you understand the judgment. That's not a precedent that is established here. What is established here is based on the fact of this case, that the decision which he took was based on untested allegations. That's the essence.
That turns on the question of rationality. This is something else. Because at paragraph 64, the court said in making reference to this case, that's the HKSR case, Mr. Chair surprisingly omitted to mention that the courts in both the HKSR appeal and the Latif matters were of the view that the determination of the principles of abuse of process was an exercise for a court of law and not an extrajudicial pronouncement. And then the court went on to say, Mr. Chair disregarded, without giving reasons, the recommendation of the prosecution team that even if the allegations regarding Mr. McCarthy are true, the decision to stop the prosecution was to be made by a court of law. And then I read paragraph 71. So clearly on a reading of this judgment.
But you see, it's down this relates to this matter at hand. It doesn't relate to prosecutions in general. It's on the fact of this matter that this is said. It's not said that all prosecutions that are stopped must go to court. I don't think there's any finding in this judgment that says that.
Once the legislature and the lords have said that that is not the principle, that is understood, that is now said from the bench, but a reading of the judgment with respect expresses the position that should go to court, because that's what happened in the HKSR case. And your Lordship's Milady relied upon the HKSR case, which said one should go to court when there's an abuse of power. Of course, it's all tied up with balancing the merits against the nature of the abuse. But that doesn't have to happen at court. Now, if our reading of the judgment is not correct, and that no principle has been set that the prosecutor must first go to court, well, then it would take care of the first ground of appeal unless a reading of the judgment is different from what your Lordships are now expressing, Milady. But we say in effect that is the finding. If it is so that he must first go to court, if it is so that he must first go to court and get the court to allow the charge to be withdrawn, then it would mean that he acted ultra vires his powers. So, well, yes, that is said, and I'm going to deal with that ground, where we say it's not irrational, but the first ground was that on our reading of the judgment, the position is that he must first go to court. If your lordships are saying that that's not the case, that only applies in the present matter, well, then we have what the court says, but we brought the application to appeal on the basis of which we read the judgment, which says that he should first have gone to court, and that is what was said in HKSR. You must first go to court. Now turn to the second ground.
One other person has been shot dead and another is in a critical condition in hospital.
The CRL has laid charges against controversial televangelist Paseka Mutsoneng.
More than 1.3 million South Africans have been added in the past 2 registration weekends.
The International Monetary Fund warns that policy uncertainty could dampen economic growth in South Africa.
And all eyes are on the new Bok coach, Alistair Coetzee, his challenge to keep everyone in the country happy.
In National Director of Public Prosecutions and Freedom Under Law. (92), the last 2 sentences, my Lord. Now, it says he must face the charges as outlined in the indictment. We've referred to the decision in Brunt, of Brunt J.A. in NDP versus Freedom Under Law. And at paragraph 33, I won't read the full paragraphs, I'll only read the pertinent portions. Justice Brunt said, according to the NDPB's argument, the withdrawal of the criminal charges in this case must be understood against the background of Section 6 of the Criminal Procedure Act. This section draws a distinction between the withdrawal of criminal charges before an accused has pleaded, that is Section 6A of the NPA Act, and the stopping of a prosecution after the accused has pleaded, as contemplated in Section 6B. So where it's a 6B and he's already pleaded, the court must find him not guilty. Where it's a 6A, they can withdraw the charges and they can charge the accused later. And at paragraph 34, Justice Brunt says, I do not believe a decision to withdraw criminal charge in terms of 6A can be described as provisional just because it can be reinstituted. It would be the same as saying that because a charge can be withdrawn, the institution of criminal proceedings is only provisional. As I see it, the withdrawal of a charge in terms of Section 6A is final. The prosecution can only be recommenced by a different, original decision to reinstitute the proceedings unless and until it is revived in this way, the charge remains withdrawn. And then in the matter of the National Director versus Zuma in 2009, that's the judgment of Justice Harams after the Nicholson judgment. At page 75, paragraph 75, Justice Harams said, in addition, as held by the Constitutional Court, as soon as the matter had been struck from the roll by MC Mangje, the criminal proceedings were terminated and the proceedings were no longer pending. Removal of a matter from the roll aborts the trial proceedings. The effect of this is that what went before the Mshe decision was spent and a new decision to prosecute was required. The Mshe decision was not simply a review of the Nuka decision, which was no longer extant. So the point of all of this is the following.
Once the charges were withdrawn, once Mr. Zuma went to court, after the announcement on the 6th of April that the charges were the prosecution would be discontinued, 2 days later, Mr. Zuma went to court. And in court, the charges were withdrawn. They're therefore off the roll. And the only thing that can happen now is it doesn't reinstate the charges. We disagree with our learned friends for the third respondent, for Mr. Zuma. That the court found that the charges are reinstated. They are not reinstated, but the court cannot order that he must face the charges in the indictment. What would happen? So the question is always, do you appeal a judgment or an order or both? It's a complex question, because if you have, for example, a delictual action, and the plaintiff claims wrongfulness and causation, and the court finds there was wrongfulness and there was causation, and then the court says in the order, the defendant must pay the plaintiff X amount of money. When you appeal that, you don't appeal the amount you must pay. You appeal the judgment which says that the court erred in finding that there was wrongfulness or finding that there was causation. So it's very difficult to find the distinction between the two. But may I say this, Lords and Lady, may I say this? When one looks at this judgment, and we know it's a matter of enormous public interest, and there's a statement by this court that Mr. Zuma must face the charges in the indictment, it's very difficult to say that it's not appealable because it's only a statement. It's not a reason. It's a statement that's put in that he must face the charges as outlined in the indictment. And it goes further, because what would happen if the prosecutor wants to either add charges or remove charges? But this court has said he must face charges in the indictment. We say that the court went too far in doing that. I would... Well, in considering this, Justice Morley, I've wondered what would happen if there was no reaction to that statement by this court, and the DA brought an application against the NDPP to say you're in contempt because it's not part of the order. It's only said in the last paragraph under the heading finding. I'm sure the court would say that's opportunistic to come and now draw a distinction between what we said under finding just before we made our order. And if it's meaningless, it's not a reason, then it shouldn't be there. But it will be relied on by others. So we say that with respect, the court went too far by saying that he must face the indictment.
What is the effect once this court found that Mr. Mshe's decision must be over? What is the effect of that?
Well, Milady, the effect is what I read from Justice Hurrams, that once it's off the roll, it is spent. The only thing that happens next is the prosecution service has to decide, should he now be prosecuted again? It doesn't reinstate the previous decision. It's gone. It's off the roll, because it was on the roll, and Justice Hurrams said, once it's... May I have the indulgence of just reading that portion again? I'm sorry. With all these microphones, so there's very little rational connection between this podium and my purpose. 71. Oh, that judgment is 75, yes. Yes, thank you. The distinction may be that in this case he went to court and the charges were withdrawn in court, and then this matter's not on the roll anymore. Yes. Yes. My Lord, I'm not suggesting that the court should not have entertained the matter. The court was entitled to deal with what was before the court, and that was an application to set aside the decision to discontinue the prosecution. And that's what the court did in the order. It said that the consequences that follow from that will fall where they fall. The point is, my lord, that the court went too far in the judgment by saying that he must face the charges. That's the point. I'm sorry, my lord, which paragraph is your lordship on? My lord, of the heads or the application for leave to appeal? Is this of the first or second, of the second ground level? Yes. Yes, ma'am. Because, my lord, it's a motion matter. It's done on paper, and the matter must be decided on where there's a dispute of fact on the applicant, on the respondent's version, and that was the respondent's version, and appeared from what Mr. Hofmeyr said in his affidavit. Was there what, my lord? I'm sorry. No, my lord. We resisted the application, and in resisting, we say that is the defence. That the court should not have found that it's irrational. The court should have found that the decision was rational, based on the facts in the papers of the respondents. Mr. Hofmeyr said at page 248 of his papers, I had investigated Mr. Zuma's allegations. In my view, they proved that McCarthy and Ngulka had actively abused the NPA to discredit Mr. Zuma. The motive for doing so was political, but they believed that it was acceptable to use the NPA to assist President Mbeki in his factional battle against Mr. Zuma. I felt that it was important to expose what they had done. I felt it was important for the NPA to send a clear message that political interference in the work of the NPA would not be tolerated and would be exposed. Whatever they may say, my lord, about McCarthy, it's on affidavit. There's no referral to evidence, and they're bound by what is stated in these papers. There, your lordships and my lady found that Share did not balance the two imperatives. That comes out of the Latif case, the balancing the expectation that people who have committed criminal offences will be charged against ensuring that the prosecution is conducted in a fair, open, honest manner without fear, favour or prejudice. And we say that there was a balancing in the application for leave to appeal. We refer to the Latif case and what the court referred to in paragraph 63 of the judgment. The court referred to, I'm reading from the application for leave to appeal at paragraph 3.1. The court referred to Mr. Mshe's reference in his media address to the case of Rex versus Latif, in which the court stated that the judge must weigh in the balance the public interest in ensuring that those who are charged with grave crimes should be tried against the competing interest in not conveying the impression that the court will adopt the approach that the end justifies the means. And we say that the Lordships and the lady with respect erred in finding that Mshe did not balance the two imperatives. In his media statement, under the heading Background, he said that the NP had received representations pertaining to the merits, fair trial defences, practical implications and considerations of continued prosecution, and the policy aspects militating against prosecution. And then Mr. Mshe said, I need to state up front that we could not find anything with regard to the first three grounds, which includes the merits. We could not find anything with regard to the first three grounds that militate against a continuation of the prosecution. And I therefore do not intend to deal in depth with those three grounds. I will focus on the fourth ground, which I consider to be the most important, but most pertinent for the purpose of my decision. And that fourth ground is the policy aspects militating against prosecution. So he accepted that on the merits there was a case to be answered. There's no doubt about that. That's never been made an issue in this court, certainly not by us. The only question was the abuse of such a nature that even though the merits were good, that the court should still the prosecution should be discontinued. And there's reference which the Lords and Lady have seen regarding what Lord Steyn was said in Rex versus Latif, again about balancing. The second category, which is the abuse, is that in the second category the court is concerned to protect the integrity of the criminal justice system. And so we say back to our heads, and under the third ground from paragraph 20, that conduct amounting to an abuse of process is not confined to that which precludes a fair trial. They may still get a fair trial, but one looks at the conduct and to see how egregious that was. In Rex versus Maxwell, there was again reference to the principle that came out of Latif, and we say in paragraph 25, we submit that the balance of competing interests in the present matter weighed in favour of the charges being withdrawn. The kind of abuse that arose here is among the most egregious imaginable. What could be more institutionally damaging than an attempt, by manipulating the timing of service of the indictment, to swing an election in favour of a political aspirant? And we say that this seems by far the most momentous form of prosecutorial abuse. And we've referred to other cases, for foreign cases, which appear from paragraph 26, Rex versus Grant, where the court is faced with illegal conduct by police or prosecutors so grave as to threaten to undermine the rule of law, the court may regard itself as bound to stop the case. There's a New Zealand case we refer to in paragraph 28, where a stay was held to be appropriate if necessary to prevent tarnishing of the court's own integrity or an offence to the court's sense of justice and propriety. Great Yarmouth, Rex versus Great Yarmouth is an interesting matter. There the court held that the prosecution may be open to being dismissed where it brought additional charges on the expiry of custody time limits in a manner calculated to prevent the release of an accused on bail. And finally, on this point, there's obviously an outcry from some quarters where an accused, where the merits are good, does not face a trial. But one balances the interest. One balances the two interests, that persons who've committed offences should be prosecuted against the fact that any prosecution must be fair and must be honest. And there's a very interesting statement from Mapp versus Ohio, which says there is another consideration, the imperative of judicial integrity. The criminal goes free if he must, but it is the law that sets him free. And the law doesn't only apply to merits of the case. The law applies to having a proper, fair prosecutorial service which doesn't allow itself to be interfered with when decisions are taken to prosecute. The fourth ground is where we say that the court misstated what the essence of our case was. And we refer to paragraph 739 and 50. I need only go to paragraph 50 of the judgment. There, my lords and my ladies, said it was argued on behalf of the first and second respondent, the ANDPP and the DSO, in essence, that having regard to the Browse Mole report criticising Mr. McCarthy's conduct of leaking information to the media and the contents of the transcript, Mr. Mshe was justified in deciding to discontinue the prosecution of Mr. Zuma, and that his decision was rational. In our application for leave to appeal, we set out what the essence of our case was. And we say it wasn't about simply the Browse Mole report. The Browse Mole report was simply evidence to show what McCarthy was up to, what he was doing, what his plan was, what his agenda was. Our case is set out in paragraph 4.2 of our application for leave to appeal at page 8 of the indexed papers. It was rather that the first and second respondent's case was that, contrary to the NPA's statutory obligation to make independent prosecutorial decisions, Mr. McCarthy influenced and made decisions related to the timing of the prosecution that were intended to harm Mr. Zuma's chances of successfully challenging the then President Mbeki at the Polokwane Electoral Conference for the position of ANC President, and boosting President Mbeki's prospects of retaining his tenure as such. At paragraph 4.4, in essence, the first and second respondent's case was that the conduct of Mr. McCarthy, who, qua Director of Special Operations, was in effect the head of the prosecution authority for purposes of the case against Mr. Zuma, was so egregious and the process so tainted that it was not in the public interest to pursue the prosecution. That was what the essence was of our case. The Browse Mole report, of course, is very important, but that just was evidence to show what the abuse was, what was behind the abuse, and why he was doing what he did. The fifth ground is the rational link. Again, if I may start with our application for leave to appeal at paragraph 5. We say that the court erred in finding that the form of censure Mr. Mshe chose by discontinuing the prosecution failed to demonstrate a connection or linkage to the alleged conduct of Mr. McCarthy. Clearly, the principle of legality requires that the exercise of public power must be rationally related to the purpose for which the power was given. Now, we say that Mr. Mshe's decision was indeed rationally related to the purpose for which the power was conferred. The purpose of that power in this context may be to guard against manipulation and ensure that all persons who are the subject of a prosecution are dealt with in a manner which is fair and by an independent authority, not suborned or manipulated for political needs. And further, that the prosecution process is not in any way manipulated for an extraneous purpose unconnected to the actual prosecution. So we know that a rational review is concerned with the exercise of public power with a particular purpose in mind, where that power is exercised to achieve that purpose. So it's the means and end test. So there's got to be a rational link between the exercise of the power and the purpose. And the power being exercised is that of the prosecutor, to prosecute or not to prosecute. The end purpose is to ensure that all persons are prosecuted who should be prosecuted, but it's done in a fair and proper and reasonable manner. So what is the link between the two? The link is to ensure that there is no abuse between the exercise of the power and the purpose. And we say that that purpose was not achieved. The means did not justify the end. It wasn't, let's charge Mr. Zuma on any basis, regardless. They had to follow a fair and proper prosecution. And your lordships, and Milady quoted in the judgment from the judgment of Justice Hurrams in the matter of the NDPP in the appeal from the Nicholson judgment. And the court quoted paragraph 37, but did not refer to paragraph 38. In paragraph 37, which the court quoted, I don't want to read parts which are not necessary. At the top of page 295, a prosecution is not wrongful merely because it is brought for an improper purpose, says Justice Hurrams. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting are absent, something not alleged by Mr. Zuma, and which in any event can only be determined once criminal proceedings have been concluded. The motive behind the prosecution is irrelevant, because as Schreiner J.A. said in connection with arrests, the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies to prosecutions. And then Justice Hurrams goes on in paragraph 38 to say this. This does not, however, mean that the prosecution may use its powers for ulterior purposes. To do so would breach the principle of legality. The facts in High State Entertainment versus the Minister of Law and Order illustrate and explain the point. The police had confiscated machines belonging to High State for the purpose of charging it with gambling offences. They were intent on confiscating further machines. The object was not to use them as exhibits. They had enough exhibits already, but to put High State out of business. In other words, the confiscation had nothing to do with the intended prosecution, and the power to confiscate was accordingly used for a purpose not authorized by the statute. That is what ulterior purpose in this context means. And we say that is analogous to the present situation. This prosecution was used for another purpose. We're not going to the merits. We accept that on what he had before him, for purposes of this case, the merits are good, for purpose of this case. But the prosecution was being used for another purpose, and the indictment was not being served for a particular purpose. If the prosecution was being conducted properly and fairly, the indictment should have been served when it was due to be served, and not held back to advantage President Mbeki and disadvantage Mr. Zuma, which leads into the last and the sixth ground, which is that the court found that there was no attempt in the papers to explain how Mr. McCarthy's conduct in delaying service would disadvantage Mr. Zuma. And with respect, the court erred because it is in the papers. If I can first take the court to the application for leave to appeal. When dealing with the sixth ground, we respectfully submit that the court erred in its findings in paragraph 76 to 79 of the judgment, in which it failed to appreciate the true reason for the decision of McCarthy and Ngcuka to delay the service of the indictment. It is common cause that Mr. McCarthy and Mr. Ngcuka were bent on ensuring that the indictment was served after the Polokwane conference, where President Mbeki and Mr. Zuma would be vying for the presidency of the ANC. Then Hofmeyr states in his affidavit, and we quote that, he says, before the Polokwane conference, Ngcuka and others opposed to Zuma debated amongst themselves whether or not, I'll add in it, because he just says whether or not Mbeki's chances, so whether or not President Mbeki's chances of retaining the ANC presidency would be strengthened by delaying the prosecution. correctly or incorrectly, they believed that President Mbeki's chances of defeating Mr. Zuma would be strengthened if the prosecution were to be delayed. McCarthy did as he was asked to do, although it was clear that at times he did not agree with Ngcuka's instructions. Ultimately, McCarthy ensured that the prosecution was delayed. He did so for one reason only, to bolster President Mbeki's chances of successfully defeating Mr. Zuma. And then in our heads of argument on the same point, we, under the sixth ground, we refer to what Mr. Hofmeyr said in regard to the Business Day article, which was discussed in the transcripts. And Hofmeyr says the gist of the article was that uncertainty about Mr. Zuma's prosecution were harmful to his prospects of successfully challenging President Mbeki for the position of ANC president. For as long as there was not a clear decision to charge him, it appeared that it was more difficult for Mr. Zuma to claim to be a victim of political conspiracy. Yes, yes, my lady, and having listened to the tapes, he said on affidavit what his view was. Now, if somebody else expresses an opinion that wasn't the purpose, that factually it wasn't the purpose, this court cannot, with respect, decide that it was not the purpose as articulated by Mr. Hofmeyr. Then that issue should have gone to evidence. We end off in conclusion by saying, in DA versus President of the Republic of South Africa, the Constitutional Court, in dealing with challenges on the grounds of rationality, referred to the fact that rationality review is really concerned with the evaluation of a relationship between means and ends. It is submitted that this in turn means that a court considering a review based on rationality will exercise a discretion in balancing the two imperatives referred to in Latif. Ultimately, the court exercises a value judgment. In so doing, the court has to exercise its discretion based on standards and form a perception as to whether the malpractice by a law enforcement agency outweighs the need, based on the particular facts, to protect the public from crime. And it is on this basis that we submit that another court would come to a different conclusion. And no, my lord, not submitting that. The process became tainted when it was found out what the prosecution was being used for. Other than to prosecute Mr. Zuma, it was also being used for the ulterior purpose of ensuring that President Mbeki retained the presidency of the ANC at Polokwane. And the process of serving the indictment tainted the process, but the original decision, before anybody knew about the transcripts, before anybody in the prosecution service knew about these transcripts, that wasn't tainted. So we end off by saying it is on this basis that we submit another court would come to a different conclusion. This is a case which impinges upon vital constitutional questions of peculiar public interest. And this in itself constitutes a compelling reason why leave to appeal to the Supreme Court of Appeal should be granted. And we also submit there's a reasonable prospect of success. And the issues in this case, my lords and my lady, they are of great constitutional import. They concern the President, they concern powers of the NPA, and there are certainly compelling reasons in a matter of this nature why leave to appeal should be granted. So we would ask the court respectfully to grant leave to appeal to the Supreme Court of Appeal. Well, my lord, there are a couple of reasons. In the first instance, I think one must respect the structures, and not and one should go through the SCA. Secondly, the Constitutional Court does not only deal with constitutional issues now. The SCA can deal with them as well. The test now in the Constitutional Court is whether it is in the interests of justice for the matter to be heard, and that would be the jurisdictional ground why the Constitutional Court can hear any matter now, even if it does not have a constitutional issue, and if it involves an important legal argument of public interest. But I think importantly, the Constitutional Court, as I understand it, has said on more than one occasion that they don't want appeals directly to that court. They want the benefit of the input of other courts as well. So there's no reason why they should not have the benefit of the Supreme Court of Appeal. Thank you.
Lords and ladies, we have also, in pursuance of the directive handed heads to my lords and lady, I assume you actually have the seat. Thank you. I am not going to repeat or try and overlap with my learned friend. I'm going to try and shorten proceedings because this is not an opportunity for re-argument. May I first say this consequent upon the debate, the understanding of a third respondent is also that this court held that where representations are made based on prosecutorial abuse, it is not appropriate and it is not valid for the prosecuting authority to determine to stop that prosecution based on such representations. And may I say to my lords and my lady, in saying that, we are also mindful that was actually what the DA tried to argue before you. And I'm going to refer to them as the DA rather than applicant, respondent, etc. They still argue it in their heads before you today. And we dealt with it in our heads, and we referred you, for example, to section 342A, which contemplates the Attorney General, as the text reads, considering if a court has struck it off for delay, whether there can be a reinstitution of prosecution. And he said, well, if you look at that, the legislature clearly intended the Director of Prosecutions, or National Director of Prosecutions, to have a power to decide on issues like that, because delay and all that are all typical abuse premises for permanent stay applications. In our heads, we, for example, say, not the ones that were to be filed now, but previously before the court, the DA suggests that a permanent stay application's implication can never be a matter for an NDPP to consider in deciding to prosecute or not. They are saying, well, you must go to court about it. And what we read in the judgment is at paragraph 68, it says a court of law is the appropriate forum to deal with the abuse of process doctrine, not extrajudicial process. And that strengthened our impression that that argument found favour. And it is a matter of considerable importance if that is so or not. Because, say for example, the decision in this matter stands and one wants to go back to the NDPP to make representations. Are representations like that at all relevant to make to him? Because if he should not or cannot, or it's not appropriate for him to decide on that, one is simply wasting your time making representations about that. Now that issue, if nothing else, has got to be cleared up by the highest courts in the land. And my lords and ladies, my learned friend is quite correct that even if we want to go directly to the Constitutional Court, as I understand the Constitutional Court's jurisprudence, it says where it is feasible, they want the input of the Supreme Court of Appeal. You go to them as a measure of last resort. That's why an appeal would be appropriate to the SCA. And my lord, we do say that contention by the DA, which it may be that got reflected in too broader terms, unfortunately, in your judgment, is indeed quite incorrect. And indeed, it cannot be that if we now bring a permanent stay application following this, that the NDPP cannot at some stage say, look, I've read your permanent stay application. I have to, as iconic counsel for the NPA previously said, we would have to concede a great many things in such an application. It cannot be that the NDPP cannot say, look, this is hopeless, we've got a hopeless case. We're not going to proceed further with it. And what it seems certainly the dicta that my learned friend has referred to, and the ones that we have referred to you now, and the DA's argument is that that is exactly what they're trying to say. Now, if they're trying to say that, it is a matter of great importance that we do have resolution of that, because we say they are fundamentally wrong. And it's not only a question of the NPA's powers, etc. It's also a question of accused people generally. What right do they have to make representations, and what can they base these representations on?
It's also in context with what said in paragraph 69. In paragraph 69, but always is view that the court would be the appropriate court. Suddenly, he decided to change. In fact, it was always his view and the view of the team that, as it was quoted in the letter that prepared with what he said to the five attorneys, they said, well, I do not consider that this matter itself will prevent the client from being over. If your client views are wrong in this assessment, then you will have the opportunity to persuade the court in this intended investigation or to trial itself. It's always is the matter.
But, my lord, the NDPP can always say to any accused who makes representations to him, Look, I'm not persuaded. It's always open to you to bring a permanent stay or to have a go at this in your criminal trial. I don't see how that detracts from the fact that you can say to him, just consider carefully whether actually you want me to go that route, because this is what is going to happen if we go that route. Think whether it is responsible for you to waste your resources, the public money, on a matter where there are significant problems for you to, in the end, be successful in the prosecution. Of course, you can turn around and say, well, I'll take that risk, I'll run that risk. But you can also turn around, and that's all we say, and say, look, I've looked at things again. I don't think that it is a good idea to carry on with this prosecution. I think that there's been sufficient evidence here to persuade me that in this case there has been unconscionable and use of the NPA to achieve political purposes. That you cannot do. There are jurisprudence all over that says that you cannot do that. And, my lords and ladies, I understand what you say to me, but I have the same problem that if I arrive at the NDP, he's going to say to me, if I say, but look at these instances of abuse, he's going to say to me, but let me read something to you. A court of law is the appropriate forum to deal with the abuse of process doctrine, not extrajudicial process. Don't talk to me about that. That is the problem. And that's why we say that couched like this, it cannot be allowed to stand. And the SCA must deal with that, and it must deal with the DA's argument that it's so fond of, that you cannot discontinue a prosecution for issues like this. You have to let the matter play out in court. That is their case. So let them put it before the SCA. Seemingly, that case is met with favour in your judgment. That is as far as I take that. And we say it is most certainly appealable on that issue. If I can then deal with another issue, what we contend on the rationality issue is, we say that the abuse here consists of a timing. But the timing and that abuse, we say, was almost like the tip of an iceberg. It was massive in itself if you look at what it was being used for, what the objective was of manipulating the time. What we say is, but look who did it. Look who took the first decision, which resulted in a dummy run against the third respondent without him being there. And it suggested that was part of a deliberate strategy. That was what had been said for a very long time. Of course, you're right when you say to me, but that's a question of inference. You don't have direct evidence that is why they did things in that way. But at least we know who did things in that way. But the problem we say, my lords and ladies, is this. There is talk in this case, and the DA hangs his cap on things not being proven. But we were not in a mini trial before the NDPP. Decisions to litigate or not to litigate or to continue litigation they are not made usually on proven facts. Proven to whom? On what measure? On what yardstick? Beyond reasonable doubt? Possible? Balance of probabilities? That is not, as I understood it, how any litigant makes decisions about what he is going to do in a prosecution. In this case, my lords and ladies, what you do have, we have explained carefully to you, and it is irrefutable that when the third respondent brought his permanent stay application, and that is where it's now being said we must seek justice. When he brought that permanent stay application, he did not know about the brass mold investigation and its illegality. It was in response to that, and note the identity, that the chief prosecution witness was Mr. McCarthy, who deposed to the papers resisting the permanent stay. We have quoted to you what he told the High Court dealing with a permanent stay. He said, we have dealt with this case in the highest ethical manner. There are no irregularities or illegalities or anything like that. Everything has been done very properly. We've quoted that to you. It later transpired, unbeknown to us, unbeknown to the judge who sent SABC, that was blatantly untrue. At that stage, that was 3 weeks after Mr. McCauley, and he went on oath to say that both in oral evidence later and on affidavit. 3 weeks before that, he told Mr. McCarthy, "You busy with something completely illegal. Stop it immediately." We now know that he did not stop. You don't see anything about this in the heads of the DA. You don't see much in the affidavit. You don't see, even though they managed to procure the affidavit of Mr. Downer and so on, anybody taking issue with that. Now what we saying, when you look at a rationality review and you ask whether in the material before the person, would that justify his decision, because it's an objective test, rationality. We have quoted you the pharmaceuticals case. It's an objective test. You look at what happened, you look at the purpose of the powers, etc., etc. And you ask yourself, was it irrational? If you look at all that material, is it irrational to say that this prosecution is tainted? And what we say to you, it is not irrational. We have quoted to you case law from English law, and you will recall that in a full judgment, when dealing with reviews of prosecutorial decisions, the court
cases that you refer us to. We'll take a short 15 minutes session.
Very well.
Karen, you know what we need?
A very good afternoon. You're watching the midday.
Chocolate is seriously like,
Do you want me to go get you some?
I'm going to give you a cash on you. Just one little chocolate and two little chocolates, just something. Three little chocolate. Four. Peter also needs chocolate.
Okay. Good sustenance.
Very we want to negotiate with
or should we continue running? Should we continue running? Okay, let me send you his number because he's outside. Oh, Victor, SMS any number. Or just give me, just drop me an SMS and I can. Yeah.
Shame, I can imagine you're like,
Can I just sort of
Nobody said we don't get that.
Because you get that. I'll go.
She said, you don't want to come here for yeah, that's just the scheming over there. Yeah, you said two guys. Okay. Oh, it's yeah.
Ja, nee, gaan nie meer hang wees.
Ja.
Ja. Ek vind dit altyd moeilik is. As jy eers begin aankeer, beteken nie die sin dit
Actually,
Ek was baie lus om vir hulle te sien. Well, no, that's fine. I think I'm not going to say too much more to them. I'm going to deal with that withdrawal of charges issue, and I'm just going to deal with these issues.
You dealt with the Concord thing. You dealt with you're dealing with the abuse thing. Now. You dealt with the relief.
Can I shift this chair a little bit?
Okay, yeah. Okay. Can you get through? Okay. Okay.
Strictly speaking, they should not, because they want warmth. It's winter time. First day of spring, they're gonna break up. You know those winter rumors? It's happened to me. I would know all those used to take in your bag. That's the worst thing when you find out how much it's used to take for warmth.
Like with the eyes.
Hurtful.
Well, I'm sure you do it as well. Like, where are my legs?
She's not getting
In my
involved.
line. But even the girls sometimes want to bring them in. make sure that you have your judgment clear.
What shit are we talking about? Seriously.
Thanks.
Madam. Keep it for later.
Later. Something to look forward to after sunset. Now that Cassim's something else, he goes doing it and he plays squash. And then,
Don't tell anyone.
nothing sport is squash.
Sport is his life. Sport is his life.
Expose. I mean, now I get to watch the SABC. They always do that. They always include the SABC. And what type of video do you post on Instagram? So what?
No.
I think probably close to 1 o'clock. I won't be too much longer. I'm going to say what I want to say. And if they don't want to, we'll go to the SCA, and if not, we'll go to the Concord. Yeah. To say that you must give.
One thing we were talking about is continuity.
Yeah. Okay. Yeah.
I used that successfully recently.
But she will deal with it and then reply.
I asked when then to the president of the SCA.
Well.
Have you ever encouraged him to? Have you ever encouraged him to pursue? Yeah.
He's not, he doesn't have a thing for her. He's just
Fascinating.
yeah, for British people, it's very hard to understand.
All right.
it appears in our old heads at page 38 of them, if my lords and lady want a reference to it. And I'm reading it in a relevance manner to you. In other words, I'm leaving out what I think are irrelevant words. It's stated, in our judgment, if in the course of an abuse argument, prosecution witnesses lied in evidence to the judge, it is to be expected that if the judges know of this, or this Court of Appeal subsequently learns of it, an extremely serious view will be taken. It is likely that the prosecution case will be regarded as tainted beyond redemption, however strong the evidence against the defendant may otherwise be. What we are simply contending is whether it is irrational for the NDPP in this case to decline to prosecute in the presence of considerations similar to those which may find a permanent stay. We have shown to you that the material before him reveals circumstances in which highly respected courts have said, we don't care how strong the evidence is. If you have lied to a court where there was a permanent stay application, then it is likely that your prosecution is going to be struck down. Now, of course, we're not dealing with a permanent stay before you. What we're simply saying, it is not correct to say that the decision, and the decision is one to discontinue the prosecution, that the decision is irrational if there are indeed very rational circumstances and facts and material before the NDPP, which in analogous instances, even courts, where they are faced with the opposition of the prosecution, have said, well, this is what you've done, we're not going to allow you to continue this prosecution. It is not a question whether my lords and lady as the NDPP would have done that. It's not a question whether I would have done it or the SCA. It's simply a question whether that falls within the permissible ambit of the NDPP's powers. And we say, my lords and lady, that it most certainly does. In the full judgment, my lord and lady, the court specifically, if I can just get for reference, said that this is why courts don't interfere with the decisions of the DPP or the NDPP. Yes. May I say this to you? If you, and I'm trying to confine myself to the papers that was eventually put before you, you will see there that even in the oral representations there are reference to the brass mole operation and what was said. You will recall I drew your attention to a passage in Mr. Mache's statement where he says, listen, there were occasions when I also ascribed to this nothing wrong with it, indicating, well, I didn't know better at the time. But the papers, all those things, he had access to everything, and the brass mold issue was raised. You can see even from what is put before you that it was raised. You will see there's a note during the oral presentation that there's a cross-reference, because my lords and ladies, you must recall that you haven't got the written representations. So that clearly was an issue. And we have raised this pertinently in our papers. Nobody has come back and said, look, that isn't so. And there's an obvious reason why they can't say that. Because it happens to be true what the averments are. It is there, it's there for everyone to see. And what Mr. Hofmeyer and Mr. McCarthy did, not Mr. McCarthy, and Mr. Maché said, is when we heard the transcripts and when we heard about this, that opened our eyes to things that happened in the past. And we looked at things that happened in the past and allegations that were made in the past in a somewhat different manner. And we simply say, my lords and ladies, we do not think that that issue should be trivialized because the DA says, but Mr. Maché didn't spell it out in his statement. He was not under a duty to spell anything out in that public statement of his. What we say that there is reference to the representations, and obviously at that stage the defence had become aware of a brass mold. You will see it is explained in the papers that at the time of the permanent stay, the defence did not know about these things. That's why it wasn't raised and why we had to accept it. And you do know from the papers that what happened to the reports, they tried to shred every copy of the report. And that report is what we've said in our present heads. It was an ad hominem investigation to find anything incriminating against the third respondent in order to put a spoke into any higher office ambitions. And must make this submission because that is what I will submit to a higher court. I will say that there is no evidence to the contrary in these papers. And it is not surprising that there is not evidence to the contrary. My lords and ladies must also accept that the landscape has changed in other ways as well. You know that the NPA, when the Public Protector made the findings that that first decision by Mr. McCarthy and Mr. Nguka violated the rights of the third respondent, it was brushed off. We now know that you can't brush that off. The DA has gone to the Constitutional Court and together with other political parties, and those findings are, as we now know, they are binding unless you review that. The NPA has never reviewed those findings. In other words, what we say to my lords and ladies, there was a different type of scenario when Mr. Maché eventually made up his mind. And we do not understand why it is suggested, and we will submit to the other court, that to the other court, my lord, if we get leave. And My lords and my lady, you have listened to the matter, you've made your decision. I'm not going to try and convince you that you are wrong. That's not my job here today. I am simply to... Yes. And what we simply say is to my lords and lady, that such submissions have quite a reasonable prospect, because they're rooted in the facts of this case, to find favour with a higher court. One can't say that there are no reasonable prospects on that basis. My lords and lady, may I just simply deal with one issue about the withdrawal of charges. We did raise that pertinently in our heads. You are quite correct that it wasn't raised in the papers. And what we say about that is that redounds to the DA's disadvantage, not ours. If they wanted such relief, they should have asked for it, and we could have dealt with it, and we could have dealt with the facts. And that is what we said in our heads as well. But you didn't ask for that. And, my lords and lady, just as in the full judgment, you will see that the court said, but you can't get this relief because at the time that you brought this application, that hadn't even happened. So how can you have such relief? Now, I have explained to the court how this application was brought without any interim relief being sought, staying any withdrawal of the charges or anything like that, and thereafter the charges were withdrawn. It is thus not so that the relief sought was ever directed at the issue of whether the charges are just simply revived or not. In freedom under law, that was a specific issue in the one instance that was specifically addressed. It was the withdrawal of the charges that had to be reversed in terms of a relief sought. That is not the case here. And my learned friend for the NPA is quite correct when he tells you that in the saga of litigation in this matter, the courts have repeatedly held if the prosecution comes to an end, that is the end of that prosecution, and it must be then revived by an independent new decision. My lords and ladies, if one had said nothing about it, maybe it would have been in order, and one had simply, if you were of a view that the decision to discontinue prosecution was not a lawful one, simply declared that decision unlawful. Because it seems to us to be very much like a tender where you ask for the award to be set aside, which frequently would have the corollary, if asked for, that the later contract is also set aside. But it does not have that corollary as an inevitable legal consequence. There may be reasons why you can say the award is invalid, but the contract I'm not going to set aside. The same with the withdrawal of the charges, because there are a number of issues which get affected by whether the charges were live or not at the time. So we simply say that an appeal court may take a different view on those issues as well. And my lords and ladies, may we simply say that in this case, the NDPP clearly was in a process of continuing to evaluate the information that he had at his disposal. some stage he came to a decision. The fact that he did so quickly, the fact that he didn't call in the prosecuting team to say, well, I've reached my decision, do you want me to change, do you want to try and change my mind again, is neither here nor there. It cannot affect the rationality of the decision that he then made. We say, my lords and ladies, that there are, of course, reasonable prospects. We also say that this is obviously a matter of considerable moment. The DA contends that it is a complex matter. There were 3 judges hearing it. It deals with an important facet of the discretionary powers of the NPA, and may I say, my lords and ladies, because I sometimes have the impression that the DA treats the third respondent as just an extra wheel on this particular wagon. It has important consequences for the rights of accused persons generally as well. And it is thus a matter that simply by its nature, involving as it does the potential reinstatement of charges against a sitting president, which in itself is an issue. And we didn't deal with that issue because that wasn't raised on the papers. It is a case of considerable moment. Therefore, we support our learned friend for the NPA and the NDPP, and we do say that leave to appeal should be granted in our submission to the Supreme Court of Appeal.
On the last point, if you say that the question of whether there should be a stay or not in the latest of responsibility, how do you then propose to put that before you may say that leave is granted? How do you propose to put that before the Supreme Court of Appeal? Because it wasn't before, as it's not in the judgment. The question is whether, for example, as we explained the last point, that the prosecution is discretion. You cannot exercise discretion in following this judgment because this judgment that we have constraints. Now, I want to know from you when you say that that is a point which would ground reasonable prospects or the prospects of success in the appeal court. How does it begin?
Sorry, my lord put a long question to me. Can I, with dividends, ask you just to give me the gist of it?
Let me just make it clear here. What I'm saying is that you are referring to a stay of prosecution, which was not before. And you say that you conclude by saying that if we can't leave to achieve another court to find different from this condition. It was not before.
No.
So how do you propose to raise it?
No, my lord, that is why I carefully try to make the submission, my lord, that what was in issue before this court was whether it was rational for the NDPP to decline to prosecute. One of the issues that arose and relates to that rationality is he had to consider what would be the possible outcome of a permanent stay application. You will recall from the papers that he gets told emphatically by Mr. Hofmeyer in a meeting that if that happens in the light of all that we have seen now, we are dead in the water. In that way, all that we are saying is, yes, his exercise of his discretion is a much freer and a much wider one than a court would be willing to engage in granting an opposed permanent stay application. But from a rationality point of view, if the factors that were before him and the material before him were analogous to instances where even a court, when faced with opposition from the prosecution, granted a permanent stay, surely that is an important question in asking whether it's rational. And that is how I would put it before the Supreme Court of Appeal. And in our submission, it is both parties. And the cases that my lords and lady have referred to, like Latif and so on, they deal with permanent stays. Latif deals essentially with a permanent stay. Corner House deals with the exercise of a discretion. And if one reads the Fool's judgment, it says one of the reasons why courts don't intervene in the decisions of the NPA is because of a very broad discretion it has when deciding for or against prosecutions, including matters of public interest and policy. And that is where, because those are slippery concepts, one tries to say, but look, it is not just open-ended. Yes, Mr. Maché talks about the integrity of the process, but he has not lost his mind. We can show you examples where the courts have said, but hang on, prosecution, if you've done A, B, and C, I'm not going to allow you to prosecute. How much more, then, is the NDPP's power to say, well, I am not going to prosecute. I'm not going to run the risk of this. He is, in our submission, quite entitled to do that. Litigants are entitled to make decisions on potential risks in litigation, not on certainties. My Lord, I'm sorry, even though you may disagree with me, have I at least answered your question? Those are my submissions.
Primary argument has always been, and it remains, that the decision of Mr. Maché not to refer the matter to the court for a permanent stay application was irrational on the facts. It was irrational not to have the matter determined in the permanent stay application on the facts of this case. And we've always submitted that the reasons for that irrationality lies therein that there was a timetable for the permanent stay, that Mr. Maché didn't have the full versions of particularly Mr. McCarthy, that he never gave Mr. McCarthy the tapes or the transcripts. So he didn't have a complete version. Furthermore, he was advised that the matter be dealt with in the permanent stay by the prosecuting team. External counsel Advocate Trengrove and Breitenbach also said that. And finally, within his own team of top and senior management, there was actually only Mr. Hofmeyr that argued strongly, and you would see we quote the reference in footnote 15 of our heads. It was only Mr. Hofmeyr, up until to the last moment, that argued strongly in favor of dropping the charges, and his reason was that it should contribute to saving the NPA, saving the institution. The rest of them, at least on the record, never made an argument as to why it couldn't be referred to be dealt with in the permanent stay. We further submit that on a proper analysis of your judgment, the judgment does not find a general principle that it must always be referred to be dealt with in a permanent stay application, that it must almost be dealt with in court. Say that is an interpretation of the judgment, which take those passages 62 and 71 out of context. That is the primary submission, and I'm tempted to leave it there. But if I may say one thing, just one submission, about the general principle. The appeal court will never reach the general principle, i.e. the circumstances where a prosecutor may drop charges in the second category of abuse. That's the category of abuse where there's no impact on the fairness of the trial. The appeal court will never reach it, and the reason for that is, as we stated in the heads, Mr. McCarthy went to find support for his discretion that he exercised in a particular line of cases. That line of cases starts with Bennett of the House of Lords. It goes through from there to Latif. Then we find the 9 judgments of the Hong Kong courts dealing with the permanent stay applications brought by Mr. Lee Ming-Tee. He found that was the line of cases that he invoked. Now, we've pointed out in our heads, if one look at that line of cases, it talks about the judicial discretion. And if one looks at His Lordship Mr. Justice Seagrove's judgment, where he analyzes the law, and Mr. Michel's statement, there are great similarities, and we've identified the 7 points of similarity. But the one major difference is that somehow the references to the court's discretion, that it's about the court's discretion to protect its own process from abuse, those were airbrushed out of there. And we've placed those in bold in the comparison that we attached to our heads. Those don't appear there. So a higher court will be faced with this situation of whatever the principle is, what cannot be correct is what Mr. Michel did, was to go to a line of cases that specifically deals with a court's discretion in this kind of category of case, and deals with abuse of the court's process, and talks about the court's sense of justice and propriety in balancing these two factors, and simply have gone and appropriated that court's discretion, which in fact arises from the inherent jurisdiction of the court. And I'm not going to take you there, but in the Bennett case, the origin of this line of jurisprudence, it's made very clear there that it is in fact an exercise of the court's inherent jurisdiction to protect its own process. So regardless of what the general principle may be, an appeal court would be faced with this difficulty, that Mr. Michel simply transplanted jurisprudence dealing with a totally different issue, the court's inherent jurisdiction to protect its own process from abuse, and he took that discretion and applied in this case. That took a bit longer than the one submission. But those are our submissions on the first grant. On the second grant, and as I said, Mr. Borgstrom will deal with the effect of the withdrawal of the charges. But on the second grant, we can't, this is now the criticism that was expressed about paragraph 92, where it was stated that it breaches the principle of separation of powers, the statement that Mr. Zuma must face the charges. Now, on the second ground, we can do no better than repeat some of the remarks that Your Lordship Motley made, Justice Pretorius as well. It is not in the order, number one. Number two, as you pointed out, Justice Motley, the case is really indistinguishable from full. Maybe you didn't point it out in those terms. Maker makes the submission. It's on all fours with full. And Justice Brand gave the exact same order in full as Your Lordship Lady made in this case, as the court made in this case. So the remark, all that it implies is that, as stated in full at paragraph 51, the effect of the withdrawal of the charges, the effect of the review of the decision to withdraw the charges means that they're automatically reinstated. And unless something else happens, unless a permanent stay application is brought, Mr. Zuma will have to face the charges. That's the implication of the statement. If there's nothing else, may I hand over to Mr. Borgstrom for the rest of the argument.
May it please the Court. My Lord and Lady, I'm going to deal with the rationality argument. And in this regard, the Court made very strong findings that the decision of Mr. Mshe was indeed irrational. Excuse me. And we submit that, again, no matter what the approach is on the principled issues, which has been attempted to be argued by both the NPA and the third respondent this morning, it doesn't get them any further because it doesn't get them past this Court's central findings that on the facts, the decision of Mr. Mshe was irrational. And this deals, in effect, with the last four grounds that are raised by the NPA, which we submit are all themes, variations on the theme of rationality, and much of which is raised by the third respondent. In regards to the rationality argument, this is a facts-based case. The principles of rationality are now quite clear. The Democratic Alliance did not ask this Court to develop the principles of rationality review, and indeed it is clear from this Court's judgment that while the principles of rationality review were very well understood, it wasn't necessary to push them forward in any material way. It is quite clear from the cases that the decision to withdraw a prosecution is an exercise of a public power subject to legality review. It's quite clear that legality review includes as a minimum a rationality requirement. It is quite clear from the cases that rationality, as has been pointed out again today, revolves around a link between the exercise of a power and the purpose for which that power was exercised, and there's also no dispute on the principles that rationality involves both a substantive and a procedural aspect. So that's all quite clear. On the law, then, it's also quite clear that the starting point for any rationality debate must be the purpose for which a power was granted. And then again, in this regard, we'd submit that there's simply no dispute between the parties and nothing which would be of particular importance for an appellate court. And we raise three aspects in this regard. The first is that what has been quite clearly stated and appears to have been repeated this morning is that the purpose for which Mr. Mshe exercised his power was to protect the integrity of the NPA. That was stated in the heads of argument in the main case, and was accepted by this Court at paragraph 60 of its judgment, and that then, we'd submit, must be the starting point, that the purpose for which Mr. Mshe exercised his power was supposedly to protect the integrity of the NPA. The second general point we had raised is that the integrity inquiry, in this case, must involve a balancing of two imperatives. And again, this is something that is specifically laid out by this court in its judgment in very clear terms at paragraph 66 of the judgment, where the court said the one imperative is where the court does not act on the misconduct and malpractice by law enforcement agencies. A failure to do so will raise the ire of the public. The second imperative is in instances where the trial is discontinued, such as this case. In such an event, the criminal justice system as a whole, and not only the NPA, will incur the reproach that it is failing to protect the public from serious crime. Again, that principle is quite clear and accepted. The third principle which we had submitted is clear in this regard, is that in order, in this balancing inquiry, in weighing these two imperatives, what is required to justify a stay of proceedings is something quite exceptional. And in this regard, Mr. Duval has already pointed out that Mr. Mshe specifically relies on a line of cases developed from the English law, and we would submit that the import of those judgments is laid out by Lord Brown in the Maxwell case, and this is dealt with at page 22 of our heads of argument. But what we'd submit that is apparent from the English case is that there's effectively a three-tiered arrangement that the courts have held. The first range of cases are those cases where an abuse results in some sort of trial unfairness. Mapp versus Ohio, which was raised by Mr. Epstein, is an example of one of those sorts of cases. This is not one of those sorts of cases. Mapp versus Ohio dealt with a situation where there was an irregular search and seizure operation, which resulted in unfair evidence. We'd submit that this is not such a case. The second type of case which the English courts have identified are what is known as the but-for cases. In other words, but for the abuse, the matter would never have come to court in the first place. Now, the but-for cases deal with things such as irregular rendition, which we've seen, entrapment, which has been mentioned. The case was mentioned of Grant as well. That was also a but-for case. That is a case where there was a deliberate violation of an attorney-client privilege. And then the New Zealand case of Fox was also mentioned by Mr. Epstein, also a but-for case. That's where there's a breach of bargain. We'd submit that none of those cases are relevant here. What we're dealing with is the very last category that has been identified by the courts in England, which is that even though there might, in some cases, be no trial unfairness, and even though the case would have come to court but for the abusive process, it is still notionally possible that there are cases where an abuse might be so bad, so exceptionally bad, that the prosecution can't go on. But what we would highlight, that in that category of cases, the category of cases that we are in this case, it is not just any old abuse that you can point to. It must be something really special. And on that basis, we then submit that we can turn to, well, what was the abuse that was pointed to in this case? And in this regard, we know that we would submit that, again, the facts and the reasons that were put forward by Mr. Mshe, or the facts that he relied on and the reasons that were given, again, are uncontentious, and there's nothing that would require the attention of an appellate court. His reasons are specifically laid out in his 6th of April 2009 press statement, it's JS 10, to the founding affidavit at page 120. And two aspects are quite clear from this press statement. The one is what he didn't rely on. He was convinced that there was compelling evidence against the third respondent, and he remains satisfied of that fact. Mr. Mshe was also satisfied that the third respondent would not face trial unfairness. He was convinced that the prosecution team was above reproach. The indictment was still good. His reason instead rested entirely in the only alleged abuse that was pointed to in Mr. Mshe's reasons was the manipulation of the timing of the service of the indictment, either just before or just after the Polokwane, ANC's elective conference at Polokwane. And Mr. Epstein has been good enough to accept today that it was only at that point that the taint crept in this case, the taint that Mr. Mshe relied upon. So that's his reason. On the facts, we would submit that there are also no real disputes. The argument has been presented today by Mr. Epstein that the court, and both this court and the DA, were obliged to accept an explanation given by Mr. Hofmeyr for the NPA. Mr. Hofmeyr gives the explanation that he believes that Mr. McCarthy, was actuated by political motives in making the timing decision about the service of the indictment. And we'd submit that the question put to Mr. Epstein by Justice Pretorius was entirely correct. What Mr. Hofmeyr does is presents an opinion. Mr. Hofmeyr cannot speak to Mr. McCarthy's state of mind. Mr. Hofmeyr can't say what was happening or why specifically Mr. McCarthy made a particular decision on the timing issue. The facts of the case, the uncontested, uncontestable facts of the case, are the transcripts, the recordings of the intercepted conversations between Mr. McCarthy and a range of other people. Those facts are not in dispute, they are indisputable. We've got the transcript, there they are. What Mr. Hofmeyr does is to make an interpretation. He takes those facts and he makes an interpretation. And this court, we would submit, is not bound to accept Mr. Hofmeyr's interpretation. Interpretation of facts is what a court does. We are not bound to any witness's interpretation. Well, this court is not bound to any interpretation by a witness. So so we'd submit that what we then land up with is the situation where the law is not disputed, the purposes of the power are not disputed, the reasons are not disputed, and indeed the facts are common cause. So all that we need to then turn to is essentially a facts-based inquiry in this particular case. And we'd submit in this regard that the rationality of Mr. Mshe's decision quickly uncouples. The link that is required between his decision and the reasons for his power is simply too weak to sustain any scrutiny. And the first point that we raise is we submit that the court quite correctly found that Mr. Mshe did not undertake the weighing process at all. If we look at the press statement that Mr. Mshe presented, in which he presented his reasons, we can see that he was quite aware that on the one plate of the scale were all these facts that you have compelling evidence against the third respondent, an untarnished prosecution team, a good indictment. That's on the one plate of the scale. And then we know that he looked, on the other hand, to what he sees as an abuse. But what we don't see is any attempt by Mr. Mshe at any point to say how these two weigh against each other. So there's all these good factors that we need to prosecute people where there's compelling evidence of a crime. There's this suggestion of an abuse. We know that it has to be something quite compelling to outweigh the societal interest in the prosecution of an accused person. But what we don't see is Mr. Mshe attempting to make any attempt to show us how that balance actually weighed out in this particular case. But even if we accept that he did weigh them, well, what did he weigh? And indeed, what was the dreadful conduct which he was taking into account here? And we're told today that, well, what it was is that there was this attempt that the timing issue is so serious because it was about swinging an election. So swinging the elective conference of the results of the elective conference of the ANC at Polokwane. But in this regard, we'd submit that our learned friends for both the NPA and the third respondents have two problems. The one is the procedural aspects of rationality, and the other is the substantive aspects. The procedural aspects of rationality have already been touched on by Mr. Duval, and we'd submit that in this regard, Mr. Mshe's decision simply fails. He's making a decision based on the fact that Mr. McCarthy did something. Mr. McCarthy manipulated the timing of the service of the indictment, and he's saying that had this terrible result. But what he doesn't do is to go and confirm whether that's correct with Mr. McCarthy. He writes a letter to Mr. McCarthy. Mr. McCarthy says, well, I need to see the transcripts, I need to see the tapes. And there simply is no attempt to wait for the answers from Mr. McCarthy. There's this rush to a decision. And we'd submit that is a central aspect of procedural irrationality. And quite apart from everything else in this case, on that basis alone, the order that this court granted was justified. And with respect, there is no attempt by any of the parties to deal with that procedural irrationality by Mr. McCarthy in this case. There's no attempt to explain why it was that there was this rush to decision, why he couldn't wait for Mr. McCarthy's explanation, when Mr. McCarthy's actions were so central to Mr. Mshe's decision. So on the procedural aspect alone, the decision must fall. On the substantive aspect, the decision of Mr. Mshe then is that there was this manipulation. But what we've asked and what we went through in some detail at the main hearing in the matter is, where did he get the information from? How does he reach this conclusion that there was this dreadful manipulation by Mr. McCarthy? Supposedly it comes from the transcripts of the intercepted telephone calls, but if we go through those telephone transcripts, or the transcripts of those telephone calls, we submit that we simply do not see the evidence to justify Mr. Mshe's decision. Nowhere is there an instruction given to Mr. McCarthy by anybody, political or otherwise, as to the timing issue. Yes, Mr. McCarthy had discussions with various people about this issue, but the notion that there was a political instruction, or that Mr. McCarthy acted contrary to his prosecutorial instincts and duties and did something for a political motive, we submit is simply not there. What the transcripts instead show is a conversation between two friends in which they discuss all sorts of issues. The one friend is the current head of the DSO, and the other is the former head of the NDPP. And we'd submit that in the context of those conversations, this notion of a political instruction is simply not there. Another aspect which you would highlight on substantive rationality is that if the actions of Mr. McCarthy were supposedly so bad, so egregious, the worst kind of manipulation and abuse that you can possibly imagine, why was nothing done afterwards? Mr. Mshe rounds off his press statement saying that, well, there needs to be further investigation. That was never done. We're talking about the most egregious violation imaginable, supposedly, of a prosecutorial discretion, and nothing is done about it. There is no further inquiry. There's nothing done to follow up with Mr. McCarthy. Admittedly, Mr. McCarthy has moved off to greener pastures, but with respect, if there was any suggestion that Mr. McCarthy had truly acted so badly, we would have expected, we submit, that the action would have been taken to avoid a repetition of this sort of thing in the future. Another aspect then is, well, then how, if Mr. McCarthy had this, even if we assume that he had this malign motive in influencing the timing decision, how did this influence anything? What effect did this really have? And the first aspect which struck us when, at the time that this supplementary founding papers were put together, was that Mr. Mshe makes his decision solely on the basis that Mr. McCarthy manipulated the timing decision. But everything in the Rule 53 record that was put before the court points to the fact that the timing decision was in fact made by Mr. Mshe himself, not Mr. McCarthy. And we specifically pointed that out in the supplementary founding papers. And what was very striking was that in the answering affidavits, this aspect is almost not dealt with at all. All that is stated is that Mr. McCarthy supposedly made an unsuccessful attempt to Mr. Downer to convince him that the prosecution should be delayed. There was another unsuccessful approach to Mr. Hofmeyr. And then we're told in the most cryptic terms possible, at paragraph 185 of the answering affidavit, in a few lines, that Mr. Hofmeyr then approaches Mr. Mshe, and Mr. Mshe confirmed that it was McCarthy who had persuaded him that it was necessary to postpone the prosecution. Mshe felt it was McCarthy's decision. He was prepared to support whatever decision McCarthy made. That's it. That's the only explanation given. So in reply, the DA was quite correctly pointed out, this simply doesn't balance. This simply doesn't square, and called on Mr. Mshe to explain. 6 years after making his decision, it seems that Mr. Mshe's memory began to clear, and he puts forward an explanation. And the explanation which is given, well, it was all Mr. McCarthy whispering in his ear. This was a latter-day Othello, Iago whispering into Othello's ear. But we'd submit that that, again, simply doesn't square, and this court quite correctly found in its judgment at paragraph 73 to 75 that Mr. Mshe's new version simply creates more confusion and that it is contradictory. At the very high watermark for the NPA, if we try to square Mr. Mshe's various versions, what seems to come up is that Mr. McCarthy approached him and said that he wanted to postpone the service of the indictment to avoid the appearance of entanglement in political issues and the ANC's Polokwane conference. And there's nothing wrong with that, with respect. That was a good reason, the avoidance of the appearance of political entanglement. Mr. Mshe also accepted that. For what it's worth, it was an opinion that was also shared by Minister Mbandla at the time. So there was this overt, explicit, good reason that was put forward by Mr. McCarthy. But Mr. Mshe now tells us, well, in addition to this good reason that I was told, and which I bought into, there was also this implicit bad reason, that Mr. McCarthy had a second bad reason. But on this, in respect of this bad reason, we would submit that it's entirely speculative, and we reiterate that there's simply nothing to point to the fact that Mr. McCarthy, in fact, had this malign motive at all. And the last point on rationality that we would point to is the so what question. And we would submit that this court quite correctly pointed in its judgment to the fact that it is hard to understand how a delay in the service of the indictment on the third respondent would have been prejudicial to him. It was easier to understand that it would harm the third respondent if the indictment had been served on him just before the Polokwane conference. But it is harder to understand why it would have hurt him afterwards. But even if it was Mr. Mshe's intention to harm the third respondent, and we'd submit that that's not entirely clear either, but even if it was Mr. Mshe's intention to hurt the third respondent at the Polokwane conference, he was just wrong. It made no difference. Mr. McCarthy may have thought that he was going to do the third respondent wrong, but he was delusional. He just got it wrong, if that was his intention. And we'd submit in those circumstances, this is not the kind of abuse which this court would raise the concerns of this court, or should have raised the concerns of Mr. McCarthy. Instead, what we see is that what we have in these circumstances is... So what we submit that we have in this case, then, is one in which Mr. Mshe ought to have proceeded on a rational basis with the prosecution. Excuse me, slight confusion. What Mr. Mshe instead did was to make an emotional, rushed decision clouded by unsubstantiated speculation, inadequate investigation, confusion, and no apparent prejudice. And the question then is, how does this weigh in the balancing process that he was supposed to do? And we submit that the court quite correctly found that there was simply no rational connection in that regard. We submit that the third respondent's argument, which is raised currently, is rather curious, because it really does seem to be premised on an understanding that the third respondent understands that the explicit reasons that were given by Mr. Mshe, the abuse that Mr. Mshe relied on, is really not good enough to get him home. And instead what the third respondent attempts to do is to come to this court and to say, well, it goes further. Because although there's this one incidence of Mr. McCarthy's bad doing, what this court should actually be worried about is a whole lot of other evil doing as well. And the one thing that the third respondent keeps on coming back to is the Browse-Mole report and Mr. McCarthy's role in this ad hominem investigation in the Browse-Mole report. And the suggestion then appears to be, well, Mr. McCarthy is a bad man, everything he touched is tarnished, and he touched everything. But we'd submit that that, again, is not something that is borne out by Mr. Mshe's reasons. In fact, what Mr. Mshe specifically noted in concluding his reasons is he looked at the Browse-Mole report, and what he states is that he had looked at the Browse-Mole report into that, and the NPA has also tried to investigate and assess the impact of revelations on other aspects of the work that has happened in the past, but that he can make no conclusions on that aspect yet. Mr. Mshe was very much aware of the Browse-Mole report, but what he specifically tells us in his reasons is that that was a matter of further investigation and that no conclusions could be made on that basis yet. So the attempt by the third respondent to now raise the Browse-Mole report again and to say, well, actually Mr. Mshe's reasons were good based on the Browse-Mole report simply doesn't bear scrutiny, because Mr. Mshe himself tells us that that is not the basis on which he made his decision. So all that the third respondent attempts to do, we'd submit then, is effectively to raise a variation on a no-difference argument. Yes, Mr. Mshe's reason that he gave wasn't particularly good, but it doesn't matter. It made no difference because we now, sitting with the benefit of hindsight, can think of better reasons. And we'd submit that that is an approach which courts have rejected since the case of Zenzile a very long time ago, and is carried forward, we'd submit, in the approach that the Constitutional Court adopted in the All-Pay decision. So those other reasons that are now attempted to be raised by the third respondent, we would submit must just be ignored. Quite apart from the third respondent and now the NPA as well submit that this court should in any event grant leave to appeal to a higher court because of other compelling grounds. And we'd submit that, again, that this is not a case which justifies this court granting leave on that basis. As we have already pointed out, this is a facts case. And a facts case and an assessment of facts is not a compelling matter we would submit for a higher court to grant to hear in circumstances such as this. It was also pointed out that, well, this is a constitutional issue. Well, it is quite clear, and it has been quite clear from the Constitutional Court's judgment since the S versus Bussack case, that facts don't make a compelling, and the reinterpretation of facts doesn't make a compelling constitutional interest which would justify that court hearing the matter. The matter may be interesting to the public, but we would submit that that is not a good enough basis for a higher court to be dragged into the matter. And the matter may be important to the third respondent, but we would submit that the third respondent has a host of other tools at his disposal as well. And we've already heard the saber rattling again that the permanent stay application will be resuscitated at some point if the prosecution continues. If the third respondent is so genuinely interested in testing the abuse by the National Prosecuting Authority in his case, he can do so. He will not be deprived of an opportunity to do that if this court does not grant leave to appeal. He can bring his permanent stay application. And we'd submit that even the Battle of Stalingrad came to an end eventually. And this is a case which we'd submit needs to come to an end at this point. And it might be a surprise for the third respondent to realize that in that battle he comes off more as General Petrus than General Zukov. As far as the consequences for the relief go, the argument is now raised that the order of this court is inadequate because it doesn't deal with the withdrawal of the charges before the KwaZulu-Natal High Court in April 2009. And we'd submit that this is a misunderstanding. First of all, we'd submit that the withdrawal of charges is regulated by Section 6A of the Criminal Procedure Act. That differentiates between two different situations. The one is where the court would grant an acquittal, and the other, which happened in this case, is where all that a withdrawal does is alleviates the duty on the accused to plead. So when the charges were withdrawn at that point, what it meant in practical effect is that the third respondent didn't need to enter a plea. If this court's order stands, what it will mean is that it will be open to the National Prosecuting Authority, we submit, to re-enroll the matter in the KwaZulu-Natal High Court, and Mr. Zuma will then, the third respondent, President Zuma, will be required to plead at that time. But even if the current indictment or the current charge sheet has somehow gone stale over the intervening period, or would submit that that also isn't something that need not be a particular moment to this court, because the as was pointed out in the full judgment at paragraph 61, which has also been referred to, is that the underlying decision to prosecute stands. The 2007 decision by Mr. Mshe to prosecute the third respondent still stands. What also stands are all the subsequent decisions made by the National Prosecuting Authority after the decision to prosecute, the decisions to consolidate the charges, the decisions to go forward with the organized crime charges, and as well as the drawing up of the indictment. All of that stands. If the current indictment is somehow stale, all that needs to be done is that it needs to be reserved. And it's not for this court, with respect, to go and tell the National Prosecuting Authority what it needs to do or what it should do or what it can do and can't do. The National Prosecuting Authority must determine that, and this court was quite correct not to dictate how that should happen. And the suggestion that also appears to be made on behalf of the third respondent, that this court somehow erred because it ought to have regulated further consequences, such as the permanent stay application. If the third respondent wants to bring his permanent stay application, he can do so. The consequences of that application will be dealt with at that stage. So in the circumstances, my lords and my lady, we'd submit that the judgment of this court is one that should stand. Leave to appeal should be refused, and we would ask for the costs of 2 counsel in that application. Unless there are any further questions, those are our submissions. As the court pleases.
I'll be brief. Answering some of the points which have been raised. It seems that the heads of argument found on behalf of the VA that it was a re-argument of the entire case, but we will extract those questions
which we believe deal with the parts where we criticize the court for being wrong. The first point is that Mr. Duval said that in context, the decision to go to the court, for the court to decide whether there's been an abuse of process, must, as I understood him, be seen in context. Now, that is not in accordance with their case and the heads of argument. In fact, I want to submit that they see this issue about going to court and not allowing the prosecutor to take the decision. Their approach to it is the same as ours, and they've read the court's judgment in the same way. If I can take you to their heads of argument, at paragraph 13.6, they say the following: the difficulty of the NPA is accordingly that the fons et origo of Mr. Mshe's decision is to be found in a line of cases which makes it clear that the discretion to determine whether an abuse of process justifies a permanent stay is vested in the judiciary and not in the prosecutorial authority. That's a general principle that they're stating. 13.8, if such a discretion were to be recognized for the prosecuting authority, which we submit should not happen, they say, it will have to be trimmed from the most exceptional of circumstances to an even narrower category of cases. This will be necessary because the prosecuting authority is then granted authority to essentially prejudge what will offend the court's sense of justice and propriety. 13.9. Mr. Mshe did not apply his mind to any of these considerations. He simply appropriated the judicial discretion recognized in Ming, T and Latif line of cases. For the reasons set out below, he misapplied the test of the facts. Then they say, but Mr. Mshe also, by prejudging the matter, usurped the function and the discretion of the judiciary in these kind of matters. And then finally, in 13.10, they say the determination which Mr. Mshe made, that is, that an abuse of process justified the withdrawal of charges, is one usually made by a court, as proven by the line of cases on which Mr. Mshe relied, and lies in the heartland of the judicial function. It was Mr. Mshe who usurped a judicial discretion contrary to the separation of powers. So for them to argue now that this must be seen in context, we appeal the judgment, we appeal what we see written in the judgment, but the fact is that they themselves sought as well that your lordships and milady had stated this as a general principle. The second point I want to address, arising from what Mr. Bergstrom's address, is he says that the abuse must be exceptional before the prosecution can be discontinued. We submitted that abuse to help a political aspirant to reach the highest echelons in our society is a very, very serious abuse, and the type of exceptional abuse that Mr. Bergstrom refers to. But it's a matter of discretion. And we submit that another court would come to a different decision when exercising this discretion as to whether this was a serious enough abuse to discontinue the prosecution. He refers to the fact that a question Milady raised, and that is the opinion of Hofmeyr. We've dealt with the transcripts and the content of the transcripts. And when one looks at the transcripts, it's clear from that one draws an inference. And in these instances, this is the only inference that can be drawn when one looks at what was exchanged in the conversations between Ngcuka and McCarthy. And then he says that nothing was done about McCarthy. Well, in terms of the National Prosecuting Authority Act, it's only the President who can take a decision to suspend and hold an inquiry. That was President Mbeki at the time. And what happened to Mr. McCarthy? He left the NPA and he went off to the World Bank to head up the Department of Integrity. So he didn't fall anymore under the jurisdiction of the NPA. And then finally, before I get to the final point, I want to say that Mr. Bergstrom said, well, he doesn't know what was in Mr. McCarthy's mind, but he got it wrong. Well, that's not the point. The point is that he was using the process for a purpose which he thought could be achieved. The fact that he got it wrong doesn't make it right in hindsight. And finally, in paragraph 51 of the DA's heads of argument, the following is stated, if I may read the whole paragraph. Furthermore, the order granted by this court sets aside Mr. Mshe's impugned decision. It does not compel any action. Setting aside the impugned decision has the effect that the 2007 decision to prosecute the third respondent still stands, and all actions taken pursuant to that decision, including the drawing of the indictment and its approval, also stand. It is not open to the NPA to now merely ignore the 2007 decision to prosecute and the actions taken pursuant to that decision. Well, that accords with what the court has said, that he must face the charges in the indictment. But I've referred to the cases in both the Brunt JA decision and the decision given by Justice Harms, that once it's off the roll, it's gone. The only thing that can happen now is they must start from the beginning. But the DA want to say that the decision that was originally taken still stands. That is a matter which necessitates, with respect to the attention of the Supreme Court of Appeal, because based on their judgment, based on their perception of what it is, of course it will be broadcast out there that the decision stands and the prosecution is now back in place, which is not the position, and another court should deal with that aspect. We submit. Those are our submissions. Thank you.
Very briefly, my lords and ladies, in the full judgment, the court made a very clear pronouncement that, secondly, there is the great width of the discretion to be exercised by the prosecuting authority and the polycentric character that generally accompanies its decision-making, including considerations of public interest and policy. The only point I want to make is that the Director of Public Prosecutions has a far greater power to prosecute or not to prosecute, or to allow a prosecution or to discontinue a prosecution compared with a court. A court cannot, on simply public interest or public policy, stop a prosecution. It would then not be surprising in a rationality issue that a Director of Public Prosecutions would say, in analogous cases, even the courts have used their extraordinary powers to terminate this prosecution. Why isn't it within my power to do it for even lesser reason, maybe, than they do? And if that is not the approach, one comes across applications like the one brought in this matter, and where third parties try and say that the DPP does not have this power, only the courts have. that is simply wrong, and on the context, the judgment seems approving of that wrong. Then, my lords and lady, I expected at some stage someone to come up with what applies to administrative law reviews. And that is that the reasons you have and give at the time are the only reasons that you can rely upon. There is, when you're dealing with rationality, which relates to an objective evaluation, no such limitation. And that has been the third respondent's concern throughout this matter, that we have put before the court material which was before the NPA when they made their decision. That material suggests that it was certainly not irrational to discontinue the prosecution. We say it is a matter of great moment then whether we are correct that that material must be considered when there is a rationality challenge to the decision, because it's the decision that's being challenged here as irrational. And we also in that regard say to my lords and my lady, the question is not whether Mr. Miché was even correct in inferring that Mr. McCarthy did certain things for certain reasons. Surely in a rationality review, the question is, could he have reasonably considered that? Not, was he correct? And now reading the transcripts, we think that there may be another interpretation. That is simply not the test, as far as we know in rationality reviews and rationality issues. The question simply is, could he have reasonably have considered, in the light of everything, that what he then understood to be going on was reasonable for him to conclude? That's a different issue. The issue that this must be proven in this case, etc., we don't see where that comes from. We think that that is, in our submission, a irrelevant and incorrect basic approach to the issues before the court. It is for that reason that we persist in our contention that there are significant matters to be decided in this matter, and that it is a case where there are significant prospects of success. I cannot see how, given the absence of any contrary evidence and what has been put before the court as to what happened in the previous permanent stay, how one can simply say, well, that's not what's before the court now. It certainly is before you, and if on the DA's approach that has been moved aside, we say another court may well consider that very differently. Those are the replies. Thank you.
Thank you, Mr. Kent. Thank you very much. What time is your flight?
15:10.
Okay. Yeah.